Tēnā. Okay, this is my final lecture with this class and our last lecture on the mental injury topic. And we're going to be looking today at Australia, Canada and New Zealand. And it may not take up the full hour. We'll see how we go. In a rather hurried way at the end of last time, I covered a summary of the Australian position, and we'll just cover that again. I don't know what this thing in the corner is doing. Never seen that before. Anyway, the leading case is Annette and Tame, two appeals which were heard together, and I covered the facts of those cases, very different contrasting facts at the end of last time. Essentially, we've seen that in Australia, they have taken a very different path than in the UK. In the UK, they have struggled to consider what constitutes a sufficient relationship of proximity. And in addition to reasonable foreseeability, they have, especially in respect of secondary victims, erected a whole lot of barriers to recovery, which have become, in many cases, determinative rules. They're not indicators of reasonable foreseeability. They are separate rules. Some of them we saw were dispensed with in Paul against Royal Wolverhampton, but essentially the position has been kind of returned to where Lord Wilberforce placed it back in McLaughlin and O'Brien. A requirement for an accident, and the plaintiff has to be physically proximate to that accident in terms of sight and hearing the accident or the immediate aftermath, and there's quite firm strictures on what counts as within the immediate aftermath. The Australian position has essentially dispensed with the special rules that have been created in the United Kingdom. Much more straightforward approach. Always a medically recognisable psychiatric injury is necessary. But then moving on to the second aspect, duty of care, the usual test of reasonable foreseeability, but of psychiatric harm, not the Page and Smith. Even for primary victims, it's reasonable foreseeability of psychiatric harm which is necessary. The same as in every other case of negligence causing personal injury. So there are no special rules, no proximity requirements. Essentially, that is all. So moving on to the Annette's case, dealing with the Annette's facts now. The Court of Appeal, from which the appeal to the High Court of Australia was taken, had declined the parent's claim on the basis that psychiatric injury was not shock-induced. Rather, it was a gradual accumulation type case. And in addition, they declined the claim on the basis of no direct perception of the death of their son or the immediate aftermath. So that's the basis on which it comes to the High Court of Australia. And as we went through at the end of last time, the High Court of Australia sweeps aside a number of the limiting principles that had been developed to that time in the United Kingdom. So just as the Supreme Court of the United Kingdom was later to do in Paul, they sweep aside the shock-induced rule. It didn't matter that these events took place over some 4 months, starting from the loss, the boy going missing, to the identification of his remains. Harsh and arbitrary, the High Court of Australia said it would rule out recovery in many deserving cases such as this. Cases also where parents had kept a vigil by the bedside of the primary victim. They pointed to a case where that had happened over 14 days. So cases of gradual onset of psychiatric illness are to be analysed instead according to the normal principles of causation and remoteness. So, is it still possible to say in such a case that the negligence caused the psychiatric injury? Is the psychiatric injury too remote? The normal principles they put their faith in, the normal negligence principles, are up to handling such a case, rather than through a precondition that the shock has to be sudden. They also had no truck with this precondition that shock had to be reasonably foreseeable in a person of ordinary fortitude. That had been applied in secondary victim cases in the UK, not an independent precondition or an absolute bar to recovery. The reason, and this comes particularly from Justice Kirby's judgment, was because of the diversity of reactions in the population, which makes it very difficult to determine what exactly the reaction of a person of ordinary fortitude, if such a person exists, would be. Also irreconcilable with the usual rule of remoteness in personal injury cases, the egg-shell-skull principle. But the reaction of a person of ordinary fortitude is certainly not irrelevant, even in cases in Australia. It's a factor that goes to determining reasonable foreseeability of psychiatric harm. In deciding whether psychiatric harm was reasonably foreseeable, one can take into account the robustness of the population at large to psychiatric illness. If the plaintiff's response to the defendant's negligence is so extreme or idiosyncratic, it may render the risk of that response being far-fetched or fanciful, such that the plaintiff's psychiatric injury may not be reasonably foreseeable. So you see how it remains relevant. And so, for an example, the facts of the Tane case. This is the woman who became obsessive about the fact that the motor vehicle collision report contained an error which suggested that she had an excess blood alcohol limit. So in that case, the High Court said she couldn't recover because psychiatric illness on those facts wasn't reasonably foreseeable. A reasonable person in the traffic officer's position wouldn't have foreseen that his conduct in carelessly completing the report involved a risk of causing this kind of harm to someone. Anger, resentment, frustration, they might be normal human reactions. They might be reasonably foreseeable reactions, but mental illness was not. And so her reaction was extreme and not one that negligence required a reasonable person to avoid. So you see how it gets factored into application of the reasonable foreseeability provision. The court also held that direct perception temporal and spatial proximity, as it's sometimes called, was liable to produce arbitrary outcomes and to exclude meritorious claims. We've seen that in particular. A mother who comes along to the hospital after 2 hours can recover, but not somebody who comes along to the mortuary 8 hours later. Both suffering the same reaction. One can recover, the other cannot. So that rule was also inconsistent. Some of you raised this yesterday with modern telecommunications and social media, where it's quite likely that people will discover or view the event via social media or learn by text or mobile phone. The High Court held that distance in time and space to the distressing phenomenon, the means of communication, may be relevant to assessing reasonable foreseeability of psychiatric harm, causation and remoteness. But the absence of direct perception didn't necessarily preclude recovery. So the Alcock proximity rules, the High Court said, were liable to produce arbitrary outcomes. They could exclude deserving claims and end up treating similarly placed plaintiffs differently. And so they declined to accept them as part of the common law of Australia. They might be relevant to assessing reasonable foreseeability of psychiatric harm, to causation and also remoteness, but not themselves decisive of liability. So on the facts of the Annette's case, the High Court allowed the claim, notwithstanding that the psychiatric harm came about from what they were told initially about their son being in peril, even though they were thousands of miles away on the east coast at the time, that they did not directly perceive his disappearance, and certainly for the mother, the father viewed his remains, the skeleton, but the mother never did. Nor was it a disentitling factor that the distressing stressor took place over several months from his disappearance to his death. Sudden shock was not required. So here's a quote from the Chief Justice Gummow in the majority judgment, the leading judgment. Actually, there's no dissent, but there are separate concurring judgments in the case. The process by which the applicants became aware of their son's disappearance and then his death was agonisingly protracted rather than sudden. And the death by exhaustion and starvation of someone lost in the desert is not a, quote, event or, quote, phenomenon likely to have many witnesses, but a rigid distinction, I beg your pardon, between psychiatric injury suffered by parents in those circumstances and similar injuries suffered by parents who see their son being run down by a motor car is indefensible. This next point is quite significant. So they sweep away the negativing elements, the barriers, but they also put a lot of stress on a strengthening factor, a special feature of the case that I referred to last time and pointed it out in respect of W against Essex County Council, which the High Court of Australia cite in support of this point. So the special feature was the fact that there was a pre-existing relationship between the defendants and the plaintiffs, the parent. Remember that key fact that the mother had sought an assurance and spoken to the wife of the station owner, an assurance that their son would be closely monitored and would be well cared for. That was a key fact which explained the outcome of the cases, of the appeal. So this special feature of the relationship between the parents and the defendants was such that the defendants should have the parents in contemplation as persons closely and directly affected by its acts and omissions in relation to their son. So those are the words of Lord Atkin in Donoghue and Stevenson, the neighbour principle. Should have had them in contemplation as persons closely and directly affected by its acts. So the parents had entrusted the care of their son, who hadn't reached adulthood, to the defendants and had specifically sought these assurances as to the arrangements for his care. And they had made known their concern to the defendants. So duty of care based on this pre-existing relationship between the parties and this assurance that had been given, which looks quite a lot like, as I said last time, an assumption of responsibility by the defendants to the plaintiffs. And so Justice Kirby says at paragraph 237 in the quote on the board, an antecedent relationship between the plaintiff and the defendant, especially where the latter has assumed some responsibility to the former, to avoid exposing him or her to a risk of psychiatric harm, may supply the basis for importing a duty of care. And refers, as I said, to W and Essex County Council, where false assurances, or assurances which turned out to be false, were similarly given. So where you have a pre-existing relationship, where you have assurances such as this, the policy concern about indeterminate liability falls away to a great extent, doesn't it? So I guess you can compare the relative rigidity of the British approach to the flexibility of the greater flexibility embodied in the Australian approach. This flexibility can assist the court in imposing a duty of care in meritorious cases, treating the various criteria as relevant factors going to reasonable foreseeability, causation and remoteness, rather than being determinative, as in the UK, does offer more flexibility. Now, of course, the downside of flexibility is that the price of certainty. But certainty can develop as the case law develops more and more cases are heard by the courts. And a picture of when the duty of care will be imposed is gradually sketched in. So it's interesting to think how this case, the Annette's appeal, would be decided in the United Kingdom, isn't it? Okay, so the summary. So in Australia, I think I've got a summary there of the Australian position. Recognisable psychiatric injury, usual duty of care test of reasonable foreseeability. It's reasonable foreseeability of psychiatric injury. No special rules in these cases. No real distinction between primary and secondary victims. No direct perception requirement. No need for sudden shock. Normal fortitude is relevant to reasonable foreseeability, but not in itself determinative. And it's really looking at the facts of each case on its merits and asking, should a duty of care be owed in this case? So you should never suspend your own reaction as a matter of fairness and justice to the facts of a case when you read it or when you later act for somebody. That initial reaction may mirror the court's reaction, because in essence that's what at least some jurisdictions are seeking to do, to determine whether duty of care should be owed on the basis of fair, just and reasonable. And they're less distracted by the concern about the floodgates, which has been front of mind in the UK. So what of Canada? Cold old Canada. The leading case we've referred to before, Sidati and Moorhead. So they're even more relaxed than the Australians. As we saw right at the beginning of these mental injury lectures, for them, they were persuaded by Justice Thomas's dissent in the Van Zoest case. No need, it's not absolutely required that the plaintiff show a medically recognisable psychiatric injury. But the mental injury must be prolonged, and it must be sufficiently serious that one can say it's outside the kind of ordinary human experience. It's outside the ordinary human emotions in response to what might be called, sort of the usual calamities of a lifetime. What's the song? I won't sing it, but into each life some rain must fall. Otherwise, the usual negligence criteria apply: reasonable foreseeability of psychiatric injury for duty of care, and that is it. They too look at each case on its merits. So remember in these cases that it's not all about duty of care. Sometimes I will read an answer to an essay or an exam problem, and the person goes on about the duty of care in mental injury, and they know that, they've got that, but they forget that they also have to consider whether the defendant has been negligent, whether there's been a breach of duty, the normal rules of causation and remoteness, and consider defences that the defendant might raise. So this is an ordinary negligence case. It's just that the duty of care issue is more complicated because of the nature of the damage, because of the spectre of an indeterminate number of claims. So, right back when we were looking at duty of care, we saw that the ANZ approach to duty of care is reasonable foreseeability. Then it's a sufficient relationship of proximity, which doesn't have a fixed definition and depends on the category of case. And then it's a question of policy considerations for and against duty, with the ultimate question being, is it F, J and R that there should be a duty of care? So this is a category of case, and we see that the definition of a sufficient relationship of proximity is made up of these special features depending on what jurisdiction you're in, right? So Anna's going to be back next week and she's going to look at cases of omission and where the defendant is a public authority and it gets its powers from statute. And that is another special category of case, right? Negligent misrepresentation is another special category of case. And in that category of case, the Carter case, Carter against Attorney General, gives you an idea of what the elements of a special, of a sufficient relationship of proximity looks like. It's about assumption of responsibility and reasonable reliance and the purpose for which the defendant made the statement, those sorts of factors. So do you get it? It's kind of, it doesn't fall into place until you get to the end of the course, and looking back, it all kind of marries up. Negligence is very much like that. So, what Siddharthi and Moorhead, what do I need to tell you about that? Remember, that was a car accident case. Again, the court says ordinary negligence criteria are what determines the outcome. So remoteness, causation is the causal relationship between the breach and the psychiatric injury. Is there a causal link? Is it too remote? Each of these elements in itself can impose a significant hurdle on recovery, but there are no special additional hurdles that must be crossed. Court said it was futile to mandate formal and separate considerations for a duty of care. So temporal geographic proximity might well inform reasonable foreseeability in some cases, but they said the ordinary negligence analysis was sufficiently flexible to capture all the relevant circumstances which might bear upon proximity. So, finally, what about, next slide, the New Zealand. Well, basically, there's the floodgates for you. We haven't had a high-level case since 1999. And we haven't had a lot of High Court cases either. We don't know how many cases get settled. And the Supreme Court of New Zealand has not delivered a judgment on this area of negligence. So you do wonder whether Justice Thomas's statement in his dissent in Van Zoest that the floodgates is over-egged, that courts go on about it, but it's not, it's exaggerated, it's an exaggerated fear. May be the case in New Zealand. It's interesting to think why that might be the case in New Zealand. But then you see the situation in Britain as a result of the Hillsborough Stadium disaster. What do you think? What is it about New Zealanders that we are reluctant to sue? Yeah.
I think that the damages are sort of like New Zealand costs too low, and also like the lawyers too expensive.
Lawyers too expensive, damages too low. That's a very interesting point. Certainly, that's very true when you see exemplary damages claims. I've written a bit on sexual abuse cases where survivors of sexual abuse sue for exemplary damages in the courts. And some of those cases concern years of pretty horrific abuse. And the court awards, the maximum they've ever awarded is $85,000. More often, it's $30,000, that sort of area. Really, as the court itself says, not enough to fund the legal fees. And certainly, you're all going to become lawyers. Legal fees are pretty extraordinary, aren't they, to take a case and stay with it over a period of time. Any other factors? What is it about Kiwis? Do you think we're, yeah?
Take responsibility for their own actions.
You reckon?
So than other countries.
Yeah? We just sort of take responsibility for what happens in life. We don't tend to blame other people and we just get on with it. Do you think? The flip side of that might be, are we too passive? Do we take things lying down? I mean, you know, you've heard, of course, in America about the cases of the cup of coffee from McDonald's being too hot and burning the person, and they sue. Sorry? Where is that coming from?
Yeah, I think it was like second-degree burns, but...
Second-degree burns, that's right.
I'm not sure how serious, but it was like quite serious. I think it was like not insignificant burns
Right.
that the media just made to seem
You think?
silly.
Okay, that's interesting. Yeah, it's overblown. But why didn't it settle, for goodness sake, you know? Yeah. Yeah?
I think with, only 50 judges of the High Court, Court of Appeal, Supreme Court, the justice system is incredibly slow here. And so that is much more of an incentive to deal with things out of court because you'll actually
Right.
get resolution. And in all of these cases, people, the reason why they're coming to court is because they want some finality of the matter. And so it's a lot easier to get that finality out of the court rather than going to 4, 5, 10 years
Right.
waiting for verdicts
Yeah.
that could end out not being in your favour.
That's very interesting. I think you know for yourselves, don't you, that you might get infuriated about an injustice, some kind of injustice. A week later, those intense feelings have waned, and 3 months later, you've kind of pushed it to the back of your mind and gotten on with life. And the thing about taking some kind of legal proceedings is that it forces you to stay with that grievance for 2 to 5 years. In my other area of interest, healthcare law, I've done a bit of pro bono work for people who have been injured by their healthcare. And it does take a lot of persistence to stay with a complaint for the period of time that it takes to get it dealt with. And at some point you kind of want to move on with your life and let it go. It's interesting, there's a bit written about vexatious litigants. So there's a process by which a person can be declared by the courts to be a vexatious litigant, somebody who brings claim after claim after claim. And the writing suggests that for vexatious litigants who bring lots of claims, so they might start their claim and they might bring it against a government department and it gets denied. So they then complain about the government department and it gets denied. And finally it goes to a court and they appeal and appeal and appeal. That very often, right at the beginning and at the kernel of the person's complaint, there is a serious injustice which is never actually resolved or dealt with, and that kind of propels them to carry on and on and on seeking vindication. And I remember talking to a vexatious litigant once and saying, listen, this has got to be bad for your health. You've got to move on with your life. You're just banging your head against a brick wall. And his reaction was one of anger that I should say that to him, you know. I remember he pursued it in the Court of Appeal and won unexpectedly, and he sent me a copy of his decision. He was absolutely delighted to be able to say, I told you so. So that this kind of quest for vindication. There's also a factor concerning the accident compensation legislation in New Zealand. So these are personal injury actions, aren't they? And certainly with exemplary damages, but also with these claims, the courts are concerned to protect the integrity of the accident compensation scheme. They don't want substitute personal injury actions coming back despite the accident compensation scheme. That's more of an issue in respect of exemplary damages claims, and so they've said exemplary damages have to be exceptional, and the awards, so that you get couch number 2, the threshold for exemplary damages, but the awards are going to be modest. And that's because they don't want personal injury cases coming back despite the bar. Exemplary damages cases essentially being substitute compensatory damages cases because people aren't happy with what they got from the accident compensation scheme. Do you see that? And they actually, the courts say that in a number of cases. It's less of a concern in these mental injury cases, I think, because the accident compensation scheme doesn't cover pure mental injury standing alone. But I also think, though, that there's kind of, it's about the judicial diet in a way, that they're not used to personal injury claims coming before them the way courts in other jurisdictions are. They just don't get personal injury claims. And when they do come, they think, well, what's this doing in my court? This is a personal injury claim. This shouldn't be here. And there's almost an unconscious reaction that it's somehow illegitimate for a personal injury claim to be before them. Do you see what I mean? Even though the ACC doesn't cover a mental injury. Okay, so Van Zuest, the only case we've got. Remember, it was a medical negligence case. It was a case concerning a surgeon, Dr. Ramstead was his name, who in the operations he conducted at Christchurch Public Hospital had a disproportionately high rate of patients who died. And it turned out that he was incompetent. He was prosecuted for manslaughter, but this was a case where the relatives of 4 of his patients who had died brought claims for their own psychiatric, or their mental distress. Remember that the case was struck out mainly on the basis that they didn't plead and adduce evidence of a recognisable psychiatric injury. But in obiter, so this is back in 1999, the court in obiter statements makes a few observations about the elements of a duty of care and talks about the Alcock requirements. I should say that the plaintiffs learned from a hospital employee that their loved one had died, and their mental suffering was later intensified when they learned that it was the result of medical negligence by the defendant, and that the hospital's systems for detecting the incompetence of the surgeon were extremely lax. So just thinking about the Alcock requirements, they would have trouble succeeding in Britain, wouldn't they, of course? They might be able to show relational proximity, but certainly direct perception and means of communication would be a problem. And of course, these are similar facts to Paul against Wolverhampton, a case of negligent treatment which caused death. The court would have to consider the absence of an accident at which they were present. So query whether Paul would be followed in New Zealand should the case be heard now. But the court looked, as I said, at the other elements, the Alcock elements, and noted the following points. Essentially, these are obiter, but should the Supreme Court consider such a case, the starting point would be Vans West and what was said by the Court of Appeal in that case. Reasonable foreseeability of psychiatric illness is necessary, they said, notwithstanding the spelling of psychiatric on that slide. And as to the Alcock criteria, a number of points were made by Justice Blanchard, who delivered the majority judgment. Relational proximity wasn't an issue because the claimants were all children or spouses of the victims, but the majority judgment accepted the position regarding close ties of love and affection taken by the House of Lords in Alcock. They said it could provide sufficient flexibility if there were this presumption of such a tie in respect of some relationships, those are spouses and the child parent relationships, so that evidence doesn't have to be produced in those cases, but you would have to establish that other less close relationships were sufficiently close and loving by evidence. So it seems pretty clear in New Zealand that you couldn't succeed as an unattached bystander to a horrific accident. Justice Thomas, in dissent, however, would have abandoned the relational proximity requirement. Instead, just as in Australia, and this was a prior to Annetts and Tame in Australia, he said, instead you would consider relational proximity as simply a factor in determining whether mental injury was reasonably foreseeable. With regard to the other proximity requirements, the majority at paragraph 74 reserved the position. But they expressed reluctance about direct perception and the other requirements. And they stated, quote, this is the second bullet point of the second bullet point, it may well be that the restrictions based on physical and temporal proximity to the accident or misadventure and the means by which the plaintiff learned of it should be removed or relaxed, and that Alcock will be seen to be unnecessarily restrictive. They noted the statements made by Justice Kirby in another case called Coates against... This is the quote at paragraph 51 of Justice Kirby in the Coates case. And they cited this with approval. Provided the requisite factors of foreseeability and proximity were demonstrated, the logic which traditionally prohibits recovery where a plaintiff has been told of the incident and its effects, as opposed to directly perceiving the incident, was unsustainable in the Coates case. Hearing by telephone or by later oral message could, in today's world, be just as foreseeable and just as directly related to the wrong sued upon as if the vulnerable observer had received the shocking perception by his or her own eyes and ears at the moment of the relative wrong. So certainly the obiter statements indicating an openness to consider the position and the facts on their merits. So that's why I've said that the law in New Zealand is unsettled, that it's all up for grabs, it's all arguable. So when it finally does come before the Supreme Court, it's going to be very interesting. It's going to be a Monty of a case, isn't it? Justice Thomas, in his dissenting judgment, I'm having trouble today with my... the trouble is that the keyboard has dropped on the floor. It disappeared behind the... Oh, I think that's the last one anyway, isn't it? Yeah. That's the last one anyway. Okay, so Justice Thomas, in his dissenting judgment, predicted the position that would be later taken in Australia. And remember that he would not insist upon a psychiatric injury either. Something approaching it, sort of extreme distress out of the ordinary, should be compensatable as well, he would hold. But he would have abandoned the Alcock criteria altogether. His judgment opens with the heading, "The law is indefensible." And he states, "Reviewing the cases, both as reported in the law reports and as summarised in academic text, I'm unable to resist the reaction that many plaintiffs have failed when they deserve to succeed." So at paragraph 83 of his judgment, he sets out the path forward in this field, if he could determine the law. He would accept that the present law is too restrictive. He would modify the actionable damage rule, as I indicated. He would abandon the rules dependent on geographical, temporal and relational proximity of the plaintiff to the accident, and accept reasonable foreseeability of psychiatric harm as the sole test of a duty of care. So, for example, relational proximity is relevant to whether the plaintiff's mental suffering was reasonably foreseeable. And that's all I have to say, actually. Oh my God.
I have something very quick to say. You guys are literally witnessing history.
Ah.
Jo Manning has been teaching tort law for 4 decades.
Ooh, that's a big number. You didn't hear that number.
This is her last tort law lecture ever. We did some quick calculations, and if Jo has been teaching for 40 years at approximately 500 students a year, 20,000 students have had the benefit of sitting and listening to Jo's tort law excellence, and you guys are the final
Post-traumatic
batch.
stress disorder.
So I hope you appreciate that you've been a slice of University of Auckland Law faculty history today.
This is weird.
Do you have...
This is the torts team, guys, who will continue on the great work of educating law students. We are lucky, it is a fantastic job, it is a privilege to be part of your education and to be able to think about the law. All the best to you all in your lives. Yeah, it's an exciting path and it's a troubled world, so we need well-educated, ethical lawyers who have a strong sense of social justice. So go well. See you all later. No, I won't. Oh, geez. That's incredible. What's the time? Oh, yeah. Oh, that's so kind. Thank you so much. I'm quite overwhelmed. I'm quite speechless.
We could go out for coffee to...
Oh, that would be lovely. On me. I don't want to.
Oh, no.
Oh, otherwise I'm not going.
You're a pain in the arse.
So there are 4 of us.
That means nothing.
That would be lovely.
Cheers. Bye. All the best.
I do not have a good phone. Jo, come with all of your bounty of goods. This lovely student has offered to take a picture.
Oh.
No, you're in the middle, woman.
Yeah, there we go. In the middle.
But
Oh yeah.
thank you so much. That's such a lovely offer.